Hi everyone, welcome back to my channel. If you haven't subscribed, please push that subscribe bell and hit the like button. I'd really appreciate that. I do appreciate all my subscribers. Today we're going to talk about the arguments on the motion to disqualify Rob Wood as prosecutor in the state versus Chad Daybell and the state versus Lori Vallow Daybell. This hearing went on yesterday. That was January 8th, 2021 at 2:30 p.m. in the afternoon. I watched it via live stream on Awen Reese's YouTube channel because I like to watch things with other folks where we can all react together and have a shared experience about what we're watching. It's exciting. I do recommend her channel. Oh, by the way, if you don't know the ruling and you want to know right now, just get it out of the way with, here's the ruling. The judge, spoilers, the judge denied the motion to disqualify Rob Wood as prosecutor, so he is going to be the prosecutor on these cases, the cases that are currently charged, all right? So if you wanted to know, and that's all you wanted to know, sally forth and have an excellent day. Now, if you want to stick around and hear the play-by-play and get a whole lot of opinions and speculation and find out what was brought forth with all this argument that we didn't know before, stick around. To start right off out of the gate, and I'm going to do a lot of paraphrasing here, okay, guys, because it was long. What happened was the state had some late filed motions. And even prior, as they sat there, was saying he hadn't received the documents. So that's never good. That's never good. And it's never a good look to file something at the last second. And, you know, there are emergencies. There always are emergencies in life. And so they filed an expedited motion to compel the testimony of Summer Shiflett. They also filed a motion to hear the testimony of Mindy Gee. That was the attorney that was in the meeting with Rob Wood, guys. And then they had an affidavit of Mindy Gee and then a supplemental affidavit of Mindy Gee. So that's what the state filed at the last minute. Instead of launch into the argument about the disqualifying Rob Wood, we got to deal with these extra stuff that got added. It's like saying, hey, before we argue, let's put this new stuff in. So it's important because if you did then have Summer come in and you have another witness come in, you're going to delay the arguments. Now they got to argue that first. And they got to take a break because Pryor hasn't even read the document in order to know what they're wanting, to craft a response, to pull case law. Here in this case, I side with the defense in the sense of give me time to look at this and read this. Don't make me object and be not, it's called sandbagging. You don't do that. And so I felt for them in that case. You don't want things filed at the last minute. It doesn't make what they filed invalid. It just makes it like you can't deal with it. So they took a good break to give the attorneys time to read the documents and to craft their responses to the documents. So I'm going to give you a condensed version of it. So then the state puts it in. They put two different, essentially, issues in. Let's get Summer in here. Let's get witness Mindy in here and all her affidavits about Summer calling the office and talking to the prosecutor. Yeah, I know, it's crazy. It's crazy. So then the defense comes in and says, no, essentially it's hearsay, it's inadmissible, it's, no, we don't want it in. So then the state will say to the hearsay, well, we have a hearsay exception to the Mindy Gee stuff. So that you go back and forth like a tennis match. And essentially, it's all to deal with Summer Shiflett. And as a layperson, you're sitting there watching this unfold and you're thinking, who is best to talk about Summer Shiflett's mental state and what she was thinking and whether she felt coerced than Summer Shiflett herself? And at one point, the state is like, she wants to speak for herself. Essentially, she's calling her office, She wants to talk to the court. Let her talk to the court. But the thing is she represented by the attorney still? Is she represented by Garrett? Was there a subpoena? Like, who's going to force her into the court and then make her testify too? It gets tricky. Believe it or not, the law of it almost leaves the realm of a normal lay person's reasoning. I swear to God, because there's always an exception, and then there's an exception to the exception, and it gets kind of crazy, and it went there. After hearing every possible argument of trustworthiness and catch-alls and the time period and all this stuff, the judge rules. So what the judge ruled essentially is that regarding Mindy Gee, the fact that she took a telephone call from Summer Shiflett is not hearsay. The fact that in the affidavit, she says what Summer said in that phone call, and maybe even in the office. I don't know if it went that far. That would be hearsay. So all that ends up being stricken from the record. So good chunks, portions of that affidavit of Mindy Gee is stricken from the record. So she isn't called as a witness. Then he has to look at whether Summer Shiflett can be essentially hailed into court. And the thing is we're not sure if she's even represented by counsel, because lawyers always reach out to other lawyers. If you're represented by counsel, the person has to reach out to your lawyer. And the fact that she reached out to the prosecutor, allegedly. She called the office. I don't know if she tried to get Rob Wood and didn't get him, and then asked to speak with Mindy, or if Mindy just took the call. I'm not sure. But the thing is usually the lawyers would talk to the lawyers. And so then they're trying to argue it was improper again. And it gets hairy. And so they were trying to say that you can't do it. And then the state's like, no, but Judge, the state can contact her with the permission of her lawyer, or the court can do it. And that's what they were saying. We're asking you, Judge, to compel her testimony because she wants to talk. And so the judge looks at everything. He looks at meanses, wanting sections of things struck. And, he just says no. He denies the motion of the testimony of Summer Shiflett. What we do find out, if you want to say, what did we find out from that? We found out that allegedly Summer called the prosecutor's office. I don't know if it was right after the last hearing or not, but she called, and I think Mindy said, can I take a message? Or someone said, can I take a message? And that they told her that they would relay her message. But the message that was relayed is now stricken from the affidavit. So I don't know what she said, but she did want to talk. Does she have an attorney? No one knows. We don't know if Garrett's still representing her, if he's not representing her anymore, if she's mad at him. We don't know. I want to say this because we haven't even gotten into the reason, like the oral argument, right? One thing that sets me off is I don't particularly care for Pryor's demeanor, because when he starts arguing, he gets louder. And sometimes people get louder because they're angry or they're excited and they're being emphatic, but he gets louder and it puts me off. I don't know if it puts you off. I think it'll put a jury off. That's just my opinion, but Chad Daybell has the lawyer he has, and he must like him. Then they go into talking about the oral argument, and Pryor right out of the gate starts doing the thing that annoys me and sets my teeth on edge. He talks about how Rob Wood allegedly disparaged material witness. We don't know yet if Summer's going to be material, but he claims that Summer Shiflett becomes relevant if they were to call her. And so therefore she's material, or possibly material, and that Rob Wood directly tried to circumvent Means's authority as an attorney for Miss Vallow. And Boyce has to remind Mr. Pryor that when he keeps citing the ABA rules, that Idaho rules of professional conduct are the law that they're rolling under, and that the Idaho rules have their own variation of, things. The ABA is a guideline, and Idaho doesn't always follow the guideline, and they have variations. And he has to remind Pryor of that, which is rather charming. And what's charming is Pryor says, in the spirit of the ABA, Idaho rules. And it's like, you just want to kind of laugh, like he just told you the Idaho rules were slightly varied, and now you're saying in the spirit of the ABA, not to allow undue influence by a party or an attorney to give a fair and impartial trial. But, he goes on saying things like, talking about a 20-minute monologue, wasn't 20 minutes, that Wood disparaged the counsel, that he disparaged the defendant. He also brought up the question of whether you expect a prosecutor to live by a higher set of rules than, say, even like an irregular attorney. So he was then saying, not only do you have these rules about what you don't do, prosecutors should be held at a higher standard of rules. And that he also proffered or said that they used expert witnesses. They, seemingly meaning he and Means, used expert witnesses because they didn't want to put Summer Shiflett on the spot. So Are they working as a team? Because I thought Means was the one that called the expert witnesses. Maybe I'm having a brain fart, but if so, it's like we used the expert witnesses because we didn't want to put Summer Shiflett on the spot. It's like, wait, like, y'all have different clients, right? Y'all aren't a team. There's points where I gave pause that could just be me misreading it. The thing that set my teeth really on edge and got a lot of people in chat upset was that when Pryor said, Wood is lying, he's doing nothing but trying to influence, coach, intimidate the witness before she's in front of a trial. And then again, he has to be reminded, like, we're not in front of a trial. He then goes to talk about when Mrs. Gibb was on the stand, Melanie Gibb, and he says, I observed Miss Gibb look in the eyes of Mr. Wood. What if these 20-minute monologues occurred with every witness? He's making it like Mr. Wood is just this grand manipulator, like this Rasputin that goes in there and woo, like, woo, in 20 minutes I will make you mine and you will say what I want. What in the world? I mean, reaching. So then Pryor goes off, what people in the chat seemingly thought was threatening the judge when he's like, you're going to have to require me to call all my witnesses again and call all these experts again, remove Mr. Wood, and there'll be additional, requests about the witnesses down the line to cure this atrocity. Rah! It was hyperbole at 100, or 99 out of 100. Just hyperbole, like lying, cheating, stealing, that kind of hyperbole. It's like, really? Because when you take it to the most extreme, it dilutes what you might have really had. He did say something kind of not sweet about Mr. Means. But when you take it to the level of lying, cheating, oh, this atrocity, oh, the inhumanity, it's too much. It's too much. So Pryor goes into this spiel about Idaho Rule 4.2 about contacting someone who has legal counsel. And in this case, he's talking about Summer Shiflett and implying that Wood was indirectly communicating with Lori Vallow by talking to Summer Shiflett. Boy, I mean, that's intent. That's like saying that you got in Wood's head and you knew that's what he was trying to do. It's reaching. Oh, he also went as far as to say, as Mr. Woods' behavior was a learning moment on what not to do. That's what he said, that's what the experts said. Mr. Woods' behavior is a teaching moment, a learning moment on what not to do. He talks about fishing and cheating and lying and breaking the law, and that he got caught, and who else did he do it to? It was, like I said, hyperbole on 100, and it turned me off because it was just too much. If you exaggerate too much, you've lost it. You know what I mean? You might have had a kernel of something that needed to be addressed, but now you've just gone. It was too much. Means' argument. In sum, the recording, the transcripts have red flags of that meeting with Rob Wood and Summer Shiflett. He said it was disgusting how Rob behaved. He asked, why in the world was Wood present in any of this? This was something that should have been essentially dealt with the police. Why was Wood even there? He kind of threw aspersions, like why was Wood in Hawaii, like when the different things were served. Why was he in Arizona? Almost planting it like like a Rasputin. That's my interpretation. Like, why is he there? What's he doing? What else is he doing to the other witnesses with his... If he talked to Summer for 20 minutes before she went and talked to the police, who else did he do this to? This horrible thing. Oh, wow. It was something else. It really was. And since the judge had kind of ruled against the state in the first part of their late file documents, it made you feel that the judge was kind of going to go for them on this too. It really didn't look that great by the feeling of it. But if you know a little something about the law, you let someone make their record. And you're letting the defense have leeway to make their record and to state everything they want. And they let the state also bring in all the case law. So the state brought case law. That's what they did. They brought the case law. Defense brought feelings and arguments. Okay, yeah, they brought their expert witnesses, but the expert witnesses were talking about people they hadn't met, and they were talking about a situation that, they listened to a recording, but the transcript wasn't 100%. So that's what you came to the table with. And guess how the judge ruled? He ruled for the state. I could go on and on and on and on about what they said, and I've seen how many pages of notes I took here. Do you want me to bore you with every hit of the ball over the net and then how the other one hit it back? Honestly, I think my audience doesn't want to hear this. I mean, they even got into the 6 issues of how he had done naughty things. He violated the defendant's right to a fair trial. The prosecuted violated the rules of Idaho professional conduct and the ABA rules. Number 3, that Rob Wood engaged in witness tampering and intimidating. 4, that the prosecutor now was a material witness, or could be a material witness. 5, that the prosecutor could now be in a future civil action. 6, there was a Brady and Rule 16 violation, concealing evidence against the Idaho Rules of Criminal Procedure. And this is the kind of stuff that they just throw it out there. And so the state comes and they bring the case law to argue against all this stuff. So then what happens is Evans comes in and he's going to make the argument against these 6 major sections, these 6 major categories where Rob has done wrong and fallen short, as his job as prosecutor, and then should be out. He says, let's lop off the low-hanging fruit. Number 2, he's saying that when the district, he brings the case law, and it essentially says that it's a decision for the Idaho Bar, the Idaho Supreme Court agreed with it. Whenever you have something like this happen, a violation of the Idaho rules of professional conduct, okay? What they do is they let the Idaho Bar deal with that. The Idaho Supreme Court agreed that it's not relevant to litigate that in the case. That's what they said. Number 4, that was dealing with the prosecutor could now be a material witness. He says you have a compelling need standard and that we have audio. And since we have the audio, we don't need Wood to be a material witness here. And he cites court cases, and he also proves that it's the defense's burden. If they're bringing it, it's their burden, and they don't meet the burden. So that, boop, it's right there. There's a compelling need standard. You don't have to bring in Wood as a material witness for that tape because the tape exists. The meeting happened, but the tape covered the meeting. That one's right out of there. So then he goes to number 5. That was that the prosecutor's conduct could result in a future civil action. And he said, could be a civil action. There's no authority. There's no evidence. You're just throwing things at the wall to see if it'll stick. We cannot disqualify someone now because a case may be filed in the future. Like, that's almost like fortune telling. He's like, it's inapplicable. There's no authority for this. There's no evidence of this. What future civil action is going to be filed against Rob Wood in this summer shiflet conversation? He's like, we can't prognosticate that. That failed. So that failed for number 5. Number 6, the Brady rule and Rule 16, where, concealing evidence. He's like, I don't even know what this is. Like, because you got to think about it. Like, Brady rule means like whenever you have evidence that's inculpatory or exculpatory, you have to give it to the other side. You can't hold on to evidence. But the thing is the only evidence that was produced in this initial thing was done by Garrett Smith, and it wasn't given to the prosecution. It was given to the defense. So there really wouldn't be a Brady violation. So unless there's something else, he's like, I don't even know what that is for this hearing. There's no Brady or there's no Rule 16, and there's no, and he's just like, there's no issue in this case. I don't even know what they're talking about. Is there something else I don't know about? I don't know where they get Brady and Rule 16. He was just like, I don't even know what that is. So they knocked out number 2, number 4, number 5, number 6. So he's left to address number 1, did Rob Wood violate the defendant's right to the fair trial? Defendant would be Vallow and or Daybell, right? And his argument is the prosecutor's supposed to talk to the witnesses. So prove that, he violated their right to a fair trial. And then number 3, the witness tampering and intimidating a witness. He's like, there was no coaching, there was no intimidation. And when there is a question of coaching or intimidation, the remedy is to cross-examine the person. Okay? But they don't want to bring in Summer Shiflett to find out that. So he's like, that's knocked out too. So he just, one by one, went through everything. He also, in addition, brought forth a case of Weaver versus Miller, and I'm not going to get into all that. But long and short of the whole entire thing is they brought the case law. They brought all the citations, all the argument to show it matches on these issues, and it left the defense denied. Because the remedy to the only thing that seemingly you could suss out if Rob had done something wrong was to bring Summer in, and they didn't want to bring her in. So, judge's verdict. Let me give it to you. So here's the Judge Boyce's verdict. I'm going to sum it up for you. The court considered the pleadings. The court considered the appropriate standard of review, that there were no Idaho cases totally on point. So there's no precedent to compare it to and say it's exactly the same, okay? Because then it makes it easy. That the defendant did not use any citation. The state used Weaver versus Miller. But the judge also said, and that's one reason I didn't get into the whole entire Weaver versus Miller, because the judge decided that it was not he wasn't going to use it because it dealt with a civil case and not a criminal case. All right, so he didn't look at that. He didn't think it was applicable. So why should I sit here and rehash it for you guys? But the judge, what he did was he found case law that was persuasive from New York. It's at 54 New York 2nd 294 State versus, I think it's like Purge something. I didn't catch the thing, and I should have looked it up, and I didn't have time to do so. But it's essentially saying that the defendant, in a pretrial motion to disqualify a prosecutor, which was like this, on a pretrial motion, the defendant has to have an adequate showing that the plaintiff rendered the trial unfair. And the two parts is, one, the defendant has to show the prosecutor's pretrial activity rendered his participation unfair, and that it was a material issue in the case. So not only do you have to show that his activity and his participation was unfair, it has to be material to the case. All right? If it's not material to the case, it's going to fall to the bar to take care of you. You follow me? So even if Summer got upset, and she was extremely upset, and Means got upset about what was said about him, they need to take it to the bar, because unless it affects this case, it's not this court's place to discipline or kick anybody off the case. So I hope that makes any kind of sense to you guys. He does get into a lot of stuff about the rules of professional conduct, is the Idaho rules.
And this is the part where my battery said, I quit you. So let me just wrap it up. To wrap it up, just to make it as succinct as possible, the judge said that he considered all the evidence, all the expert witnesses, the opinions, the arguments, the audio, and the transcripts, and he denied the motion to disqualify the prosecutor. I just want to note that there's nothing to stop anyone from filing a bar complaint against Rob Wood if they feel like that he has done something unethical. I know from experience, from working at the bar, not in that state, that pretty much anyone can file a complaint against an attorney, but you do have to swear to it. You're swearing under penalty of perjury. So you want to make sure what you say is not slanderous or libelous. And so basically anyone can file a bar complaint. There's nothing to stop anyone from filing one. I mean, in theory, would Summer likely do it, or Garrett on her behalf? No, probably not. Would maybe Mark Means or Chad Daybell on his own behalf as he sits in jail file a bar complaint? I wouldn't be surprised if Chad Daybell filed one, because you would be surprised how many defendants or prior clients file bar complaints against their attorneys or against other attorneys when they have nothing better to do while they're sitting in jail. I mean, there's really no recourse to them for filing the complaint. So basically what the judge is saying is, for our intents and purposes, he hasn't done anything wrong and hasn't done anything to affect this case as it stands. But, there's nothing to stop him from, giving an apology to Rob Wood for, what he said. And it was so funny because I could tell that Wood did kind of subtly nod his head up and down a little bit when the judge said that. And I wouldn't be surprised that seemingly Rob Wood's a nice guy. I wouldn't be surprised if he didn't on the side say, I'm not admitting any wrongdoing, but I'm sorry, Mark Means, if I hurt your feelings. So, guys, that's it. And that's all she wrote. And I hope you're having an excellent day. I hope you're surviving this, what we're all going through. I won't say it because YouTube doesn't like that word about what we're all going through right now. So anyway, I hope you have an excellent day and take care. Bye.